Stories of domestic violence are often the ones left untold, until it's too late. 1 in 5 killings in New York is a domestic homicide, which is the murder of an intimate partner or family member by another. And of the 61 domestic homicides in NYC last year, almost half of those victims called Brooklyn home. So now the Brooklyn District Attorney's Office hopes to reduce this lethal toll by phasing in a new policing tool. It's called the Danger Assessment. But just how does this program work? And while the goal of the danger assessment seems unimpeachable, could its implementation carry a risk for civil liberties? Here in the studio to talk about this are Nicole Bellina, a named partner at the civil rights law firm Stolen Glickman and Bellina. Welcome, and thank you so much for being here. I really do appreciate it. And we also have Abby Tuller, who's the executive director of North Brooklyn Coalition Families Against Violence. Thank you so much for being here as well. I just want to jump right in. The numbers that were referenced at the very top of the segment were pretty startling. Abby, can you just give me a little bit of a sense of the type of caseload that you experience at North Brooklyn Family Coalition?
Well, we often receive many different calls. Anywhere from somebody who thinks they might be in a violent relationship to somebody who's in a very dangerous and high-risk situation. So we will see anywhere between 250 to 400 families a year.
Wow. Wow, that makes,
and we're a very small organization, so that doesn't represent all of Brooklyn and all the people that are in need. That's just the people that we're able to reach at this point.
Wow. So now the DA's office is trying to hopefully step in, introducing this new tool called the Danger Assessment to hopefully help curtail or reduce, prevent some of these domestic killings. Do we know what is a Danger Assessment tool? Where did it come from? How does it work?
So the Danger Assessment tool was developed by Jackie Campbell, a researcher and doctor at, a nurse at Johns Hopkins University. And so I think it was originally developed with that in mind. Can this tool be used in a hospital setting to help us better identify cases in which there's a high risk of partner violence, and particularly the risk for lethality?
Nicole, any idea of how the tool itself works?
The tool itself, from my understanding, is literally a checklist. It is a one-page sheet that is a list of questions that are asked of the victim or the complaining witness in a case. And I answer questions as simple as, you know, is your partner an alcoholic? Does your partner use illicit drugs? Does your partner work? And I guess other issues like that that they've identified will somehow signify whether the relationship is escalating.
Identifiers as to risk, of course, the danger assessment risk. I know that the tool has been used in other jurisdictions. How effective has it been when used, for example, outside of Brooklyn?
Right. My understanding is that this tool really is not supposed to be, and wasn't ever really intended necessarily to be used directly in the criminal justice system. It is something like Abby and other workers that work with women directly or families directly can use to identify relationships or situations that need immediate intervention. So taking it to the criminal justice system, I think, is a newer step.
Do you think it's an appropriate step for the district attorney's office to do if it hasn't necessarily been used in a more criminal justice context? Now that the DA's office in Brooklyn has kind of stepped into that realm, is it an appropriate position for a DA?
I believe that as a defense attorney and also a civil rights attorney, that it poses a lot of concerns and a lot of problems.
Name some.
This tool, from my understanding, the district attorney is going to try to use to either increase bail on people who are arrested on minor offenses, or, in fact, request bail in situations where they otherwise wouldn't.
And the goal being detaining these individuals?
Exactly. And what's concerning about that is you are now asking for someone to remain incarcerated, not based on something they did, not based on a crime that they committed, but based instead on a very subjective checklist that someone else is filling out and then is being used against them. So it's essentially saying, you know, we know you haven't done this terrible crime. We don't even know if you're thinking about this terrible crime. We just know that you fit into this group, this group that we've identified.
We've answered a couple of questions, and based on these objective questions, we've come to this conclusion that you may pose a danger to a particular individual.
Right. And as a result of that, we're going to incarcerate you. And that's the most troubling part. If it was, we identify that this might be a relationship headed in a very bad direction, so therefore we're going to bring in more social workers, we're going to, pay more attention to the case, we're going to devote more resources, great. If it's taken to that next step, which is we're going to incarcerate you based on this, that's when it becomes troubling.
So what it sounds like to me is that you're detaining someone who clearly has shown some sort of aggression in a domestic context. I mean, this isn't just kind of out of the blue, out of nowhere, but you're keeping them behind bars, presumably, for something that they haven't yet done. So it's preventing someone from committing a future crime. Due process concerns in there, essentially detaining someone prior to a crime in hopes of preventing a crime. What are the worries there? I mean, are the domestic violence cases, for example, that you guys experience or work with, do they pose a special kind of concern that maybe allows for certain due process considerations to maybe be put on the back burner as far as the aggressor?
Well, I don't know that I can speak to the legality issues of it, but I can say that the measure itself, it captures a lot of these other nuanced behaviors that we see in domestic violence that contribute to some of the criminality of it. So I think it's a very helpful and very useful tool. Definitely in getting domestic violence victims to access services and get the support that they need. In particular, with it evaluating the risk for lethality, it lets us know where we need to intervene and how much this person really needs protection, in a sense.
Protection up to the point of detainment. Of the aggressor, of course, not the victim.
Right. It's very challenging. It may be used as a tool for defense attorneys to even say, hey, you're falling into this category where there's all these other behaviors, you really need to stay away from this person, And maybe it means if they violate the order of protection, harsher penalties, because we know there's a greater risk because there's all these other behaviors involved. But obviously it does bring up some of these concerns.
Right.
But it's a combination of how do we integrate.
How do you balance, of course, the victim's protection against another individual's due process rights? As a defense attorney, how do you think that this danger assessment tool will either work in your practice, or how does that work?
Yeah, I mean, just to respond to what you said a moment ago, too, I mean, I don't think we should ever really have a situation where we're putting due process rights on the back burner. That is a very slippery slope.
We have something similar in civil confinement for sex offenders.
We do.
Right? But that's controversial.
It is. We have, talking about a slippery slope, now we have where people who have mental health issues can remain incarcerated past the expiration of their sentence if doctors evaluate that they're still a danger to society. We now have for people who are convicted of sex offenses, which can be extremely minor to extremely serious, are now, despite when their sentence ends, could have to register potentially for the rest of their life, which is a very difficult and can be very interruptive to leading a normal life. So we're already sort of headed down this slope of people being punished for acts that they haven't committed, but acts that we are afraid they're going to commit. And that can, if we use it in the domestic violence context, why can't we then use it in other contexts where we have people who, if you are from a certain socioeconomic background and you get arrested for, a small amount of drugs, let's say, but if we put together the statistics, this might show that down the road you're going to be involved in more serious crime. Why not use that then? So it's this slippery slope, I think, to ever put the due process rights behind.
Right, and I guess with domestic violence being such a specific type of crime and something that's being behind closed doors, not something that's really out there in the open, I mean, I guess I can understand a little bit of both, that there are concerns that, a lot of times the victims don't necessarily speak out about what's going on, so you may have to use a checklist to kind of determine, well, is this person in a safe situation, and that sort of thing. Is that kind of your understanding as well, Abby?
Well, and I think also the issue is that, I mean, obviously the due process concerns are of extreme importance, but it's also offenses that might get categorized as one thing that ultimately really, in the context of domestic violence, are really representative of a more severe behavior.
So sorry, I was like, wait, is she finishing a thought? No worries. So one thing that I did find interesting is that this assessment tool appears it's facially neutral, right? We're basing our assessment of risk on very objective factors, someone's prior history, whether or not they own a gun, things of that nature. We had another facially neutral policy in New York not that long ago that turned out in its implementation, it was disproportionately targeting minorities and persons of color, and I'm talking about stop and frisk. On its face, it appears facially neutral, but when it's worked out, it doesn't actually flesh out that way. Is there a worry or that danger also existing in the danger assessment tool, that on its face, it's completely neutral, very objective, but once it's implemented, especially in a criminal justice system, that it may start getting clouded with other issues concerning race, ethnicity, and socioeconomic status?
I think that is a risk, and I think this tool is not as objective as we might want it to be. There are definitely questions on this tool that are, has the violence escalated? These are things that the woman, because this is meant specifically where the woman is the victim, where the woman has to sort of report about what's been happening behind closed doors, as you said. So it's not always so objective. Does your partner have a drinking problem? That's not necessarily an objective evaluation to be made. So there's definitely going to be some subjective issues here. And whenever you have that risk of it being implemented in a discriminatory way. I understand that the DA's office is going to start with a particular neighborhood of Brooklyn.
East New York.
So that's going to be a specific, racial, socioeconomic makeup where this tool is going to be used. There are questions on there, I know, as I mentioned before, about whether or not the person is employed, whether or not that person owns a gun. So I think that some of these questions are going to be answered differently based on what community they're being asked in.
Right, but of course, Abby, now this tool was created by, doctors. This wasn't like out of the blue asking these questions. These came from somewhere.
Yes, they came from a extensive body of research that we know contributes to different risk factors. A person having access to a gun obviously creates a higher level of risk. Seeing the frequency and the severity of violence increase obviously creates a higher risk. But some other more nuanced things, such as if you've experienced domestic violence while you're pregnant, we know that leads to more risk of partner violence.
Right. So there's benefits to this tool. It's yet to be seen whether or not this pre-detention or almost pre-crime aspect of it will work out the way that it should in the criminal justice context. So we'll see what happens once it starts getting implemented.